Justice Barrett?
So, General Sauer, you argue that the removal power comes from the vesting clause. And I understand why you make that argument, because that would be the broadest authority, because it would give, that would be the full unitary executive theory. But there are other theories of where the power could be located. For example, if it was part of the take care clause, then it might be more limited, because it might apply only or give removal authority only over those officers who exercise significant discretion. Or it might be an adjunct to the power of appointment, which would mean that inferior officers didn't come within it. And I don't read our cases to this point to really be very specific. They mention all three, and they could be mutually reinforcing. Is there any reason for us to be specific about it in this case?
I think the court ought to adopt, as I read the cases, virtually every time the court has decided this, certainly in Seal Law and Free Enterprise Fund, but also going back to the 19th century cases, the court looks to both the vesting clause and the take care clause. And then in other cases, it also refers to the appointments clause and how the power to remove also flows with the power to appoint. So you have three kind of mutually reinforcing textual bases to place what, again, the court's decisions from Ex parte Hennon through Humber's executor decided as a settled beyond doubt, exclusive and illimitable power of removal. So I think the text of the Constitution supports what you've referred to as the strong theory, and that's, I think, repeated again and again in this court's decisions, where it started with the vesting clause. And of course, it's the logic of Madison's statements on the floor of Congress in the decision of 1789.
Well, let's see, I know that obviously, I understand that's your first line position, and I do think that you could go back through the cases and find that, and I agree with you that we mentioned the vesting clause. I agree with you, it comes up in the decision of 1789, et cetera. But what I'm asking is there any reason that we have to? Because it seems to me that there are very hard questions. Justice Kagan in particular was pushing you on them about what the limits of your logic would be. And it seems to me that, and there's some dispute among this in the amicus briefs and the scholarship about which portion of Article 2, or if it's in the appointments clause, would be the source of this authority. And is there any reason we have to decide that here, given that it might be relevant to some of the harder questions about limiting principles?
I don't dispute that there might be narrower grounds on which the court could rule, but we'd encourage the court to adhere to the logic of all those decisions. Again, I've discussed 9 decisions from 1839 to 2024 that talks about this removal power as exclusive and illimitable, conclusive and preclusive, and so forth. I mean, that really is the line of this jurisprudence. It's a compelling logic that Madison successfully advocated on the floor of the first Congress, and we would—
So we have to do vesting clause.
We think the vesting clause provides at least the clearest textual basis for it. I mean, when Madison said, for example, the power of overseeing and controlling those who execute the laws is the quintessential executive power, that's the logic of it. Could the court devise a holding that based solely on the appointments clause? That's possible.
I wasn't proposing devising that holding. I was just proposing not being very specific about it, which I think some of our prior decisions have been. But let me move on. And actually, this is a question I truly don't know the answer to, and I just thought of it during the argument as we were talking about bargains. So both Justice Gorsuch and Justice Kagan were asking you about the bargain that Congress has made in creating these independent agencies. And I was struck by, I remember Justice Gorsuch brought up in the tariffs argument the fact that that tariff statute had a legislative veto originally. I don't know whether the original 1935 FTC Act from Humphreys did or did not. But I guess the question that I have is that part of the bargain, because legislative vetoes were pretty ubiquitous throughout the 20th century, and of course we held them unconstitutional in Chadha. And if you had a legislative veto, even if Congress wasn't exerting itself the authority to fire the head of one of a member, multi-member board, it could override decisions that the agency made. But I think I gather your point, part of your response to Justice Jackson, about why these agencies are different is it's not like they're answering to Congress either. Congress creates them and it might put the removal restriction on them, and that might limit the president's authority, but they're not answering to either the president or to Congress. But when the legislative veto was in place, there was some measure of congressional control that is perhaps more significant than budgetary restrictions. I just wondered if you could speak to that.
2 things. INS against Chadha correctly recognized that there was legislative control.
I wasn't questioning Chadha.
And Chadha, I think, very powerfully explains that that's terrible. That is a huge separation of powers problem when Congress is attached a string to its delegation to control what executive officers are doing. And And then the historical point that in Chadha, by the time of Chadha, that had been in legislative vetoes had been in place since 1932, over 50 years. There were 196 statutes with 295 legislative vetoes, and this court said they're unconstitutional. And the fact that Congress likes this encroachment power so much sharpens rather than blunts the court's review.
But that's not quite the question that I had. I guess what I was wondering is, do you think it's part of the reason Congress was willing to infuse agencies with a lot of the broad powers? Justice Kagan was pointing out they now exercise a lot of rulemaking power. There's a lot of adjudicatory power. And I'm not questioning Chadha. I think Chadha, rightly, as you said, made the separation of powers point that Congress can't retain this power for itself. But I guess what I'm saying is, having lost that check, maybe these independent agencies have become something that Congress didn't intend or anticipate even at the point that it set it up, which is the point that Justice Gorsuch made in the tariff argument with respect to IEPA.
May I just say this? I believe the FTC Act, I'm not aware of it having a legislative veto at any point in its history. I could be wrong about that. But as Chadha points out, legislative vetoes started coming in vogue in 1932, and the FTC Act goes back to 1913. So I'm not sure if that's part of the dynamic.
Let me ask you a question about stare decisis. How should we think about reliance interests when it comes to reliance interests in government structure? You know, Justice Sotomayor was pushing you about, had we ever overruled a case that was this old? And you gave lots of examples, and frankly, examples that came, I mean, Erie kind of came out of nowhere in overruling Swift, right? And here I would say there's been an eroding of Humphrey's executor over the years. But I think what Justice Sotomayor was really trying to get is not at, was there as an age gap, but this kind of decision. And I'm not asking you whether there's been another analogous decision, but I think when we think about stare decisis interests, this kind of structural interest, which is really the interest that's been identified on the reliance side. Can you think of a case that talks about how the reliance factor of stare decisis plays in here?
I think Justice Gorsuch's opinion for the plurality in Ramos addresses this when he talks about how you're weighing, here you're weighing an injury to the constitutional structure. That's not a valid reliance interest. The relevant reliance interest is the reliance of the American people in separation of powers and defending our liberties. If you look at actually like human reliance interests, like entering into marriage, starting a small business, and so forth, you don't see a lot of people making decisions in reliance on the fact that there are multi-member agency commissions have removal restrictions. The only actor here who's arguably relying is Congress, and Congress's act of reliance is itself the violation of the separation of powers. And where that's the case, this supposed congressional reliance interest should be given little or no weight in our view. And then, yeah, I think I'll say that.